You're just here to be of assistance to me then. So how is your weather? We had snow over the weekend.
It was initially cold, but now I think Mumbai generally has same weather for all the months. Means it has constant thing, not too much. You know, even summer is same, even the winter is same over here. So overall, throughout the period, it is same. But on the other part of India, it was too cold.
Mm. It's been too cold here. I'm not used to the cold.
How was your weekend, ma'am? By the way.
It was productive and restful, which are a good combination. So I had to stay in because it was snowing a little bit, and so just a good opportunity to get some rest and get a little work to get ahead for the week. So what will you do after my session? Will you eat dinner or?
Yes, ma'am. Means I might prepare for the classes for tomorrow's classes, and then I will go to my PG because I'm not local over in Mumbai. Actually, I'm from the different part of the same state, but at the different part. So I think it has been 3 months that I am in the institution. So I have taken accommodation over here at different place. So I will go there. I will have dinner with my friends. That's the routine.
Nice. So where did you grow up?
Actually, I grew up in it's a small town, ma'am. RV. It's in Nagpur. It is the part of Maharashtra, which is one of the richest state in India. So even Mumbai is part of Maharashtra, but I am from the different part of Maharashtra. Like Nagpur is far from here. Means you have to travel for 8 9 hours.
Oh
So
my goodness,
uh,
that's far.
that's far. That too in within a state.
That's a I forget how big it is. So I flew into Mumbai and then immediately went to Pune my first visit.
Pune is still nearby. I think comparative to Nagpur. Nagpur is whole at different distance. So right now, where are you, ma'am? Exactly,
I am in Charleston, South Carolina.
South Carolina.
Do you know Florida?
I heard about it, ma'am. I have
So
not visited US anytime.
so I am about 8 hours from Florida and about
Mhm.
8 hours from Washington, D.C. So I'm in between those two.
In between those two.
Between on the Atlantic Ocean.
I wish I could visit USA one day.
Please come. Please come. I keep telling Swapnil he's got to come and bring his family.
My
So
friends are there. Some of my friends are there, so they keep sending me pictures, beautiful pictures all over USA whenever they are, going outside, and it's really beautiful, man. Your country is really beautiful.
as is yours. I love
Thank you,
your country.
thank you.
I'd like to come back and see some more. What's your favorite vacation in India?
Favorite vacation? Um, I'm not that guy, man. Means I do not like traveling much. So I have not gone to number of places in India, so very limited places. But I still think uh, near to Nagpur, I will say ki Mahabaleshwar is also a good place. Then Chikaldhara is a very native place to Nagpur. That is also good. So that is what I have gone to. I have not traveled much in India. So we
I
have
hope
five
we get
more minutes.
some. Oh, go ahead.
No, ma'am, what you were saying?
I'm hoping we're going to get some more interactive participants this time. Maybe something in the chat, or somebody will ask a question.
Surely, ma'am. I think they will join
Hmm?
and they will take interest in it. Because first session was appreciated, everyone liked it, and I don't know, maybe it is difficult for them to ask the question because you are being judged what you will think. That could be their thinking.
Oh, well, I love questions. As a teacher, don't you love questions, Mr. Moray?
Yes, ma'am. Yes, ma'am. I do like questions because that help me to critically examine or critically think about the same subject topic.
Yes.
Hmm.
But you're right. Sometimes I feel like it's hard to ask, to formulate a question to where the question makes sense when you don't know the answer. So I understand.
That make us think more, no, about the topic.
Yes.
Hmm.
Yes.
Sometimes some people could pursue any topic in different way, different angle. So even that open up our mind. So asking question is always is something we appreciate. So that is what I do. I will ask questions to the student throughout the session. Ki what is this? What is that? Then only we proceed. And hearing a reply from them is also a good thing that they are somehow getting something from our teaching.
Good. And do you use so you use more of the Socratic method?
Yes, ma'am. Means in case whatever simple principles are there, we know that the student must be having idea about the same. So only those question I will ask them, and after getting response, even they get excited about the same, about the session, about the lecture. So I, with the limited teaching experience that I am having, I think I have only 1 year of teaching experience. That too in Nagpur. I have recently joined institution, so this was my first session. I have taken the first lecture in this institution.
And you made it through.
Yes, ma'am. It was tough. Student of MNLU are really, they have this critical thinking. They will ask you number of questions, but somehow I survived. Ma'am, we will start after maybe 1 or 2 minutes. That will be fine because the program is posted on, I think, on YouTube as well. So number of
Okay.
participants will be joining there also. Okay, ma'am. Should we start?
Oh, all right. Are you ready?
Yes, ma'am. Yes, ma'am. I'm ready. So, shall we begin? Okay.
Yes.
Okay. So, very good evening to one and all present here, and very good morning to Miss Christy Harrington, ma'am. I'm Abhijit More, and I'm taking this opportunity to warmly welcome you all for this second lecture of the special lecture series on topic Mediation and Conciliation Recent Development, organized by Maharashtra National Law University, Mumbai, in association with the Family Court Bar Association. The Maharashtra National Law University Mumbai is one of the premier law institutions, and the university was established in year 2014. It started its first academic endeavor in year 2015. The university disseminates advanced legal knowledge under the able guidance and mentorship of university's chancellor, Honorable Justice D.Y. Chandrachud, and under the able leadership of Honorable Vice Chancellor Professor Dr. Dilip K. The Family Court Bar Association is a professional body of lawyers that promote conciliation and speedy settlement of dispute relating to marriage, family affair, aiding the judges in administration of justice. The purpose and aim of establishing the family court is to protect and preserve the institution of marriage and promote the welfare of children, provide for the settlement of dispute by conciliation, and advocate of family bar association are working really hard to achieve that goal. As there is a need to understand the recent development in mediation and conciliation, as these techniques helps to resolve the dispute and disagreement between the transacting parties by arriving at the amicable settlement through negotiation and discussion. It provides speedy disposal of trial, economic settlement of dispute, and it is time saving. With this objective in view, MNLU Mumbai, in association with the Family Court Bar Association, organized this special lecture series on topic mediation and conciliation recent development. Many of you already know about Miss Christy Harrington, ma'am, but for those who could not attend the lecture series, let me introduce you all to our chief guest, Honorable Christy Harrington, ma'am. Miss Christy became the youngest circuit judge and one of the only six female circuit judges in the state of South Carolina on February 6, 2008, when she was anonymously elected by the state legislature. She was appointed to the Governor's Task Force on Violence Against Women as a sole circuit judge, working to reduce the number of assault and deaths of women in the state. On June 30, 2018, Christie retired from the bench after serving for the two terms. She is certified Supreme Court mediator and arbitrator, owning her own alternate dispute resolution practice, Christie Harrington Dispute Resolution. She is honored to be on American Arbitration Association and the member of Arbitral Women. Thank you so much, ma'am. Over to you, ma'am.
Thank you. I'm going to share my screen. Let's hope it works. Are you able to see it?
It is not visible, I think. It is displayed, but it is not visible.
Yes.
It is.
All right. Let me
Hmm.
hold on 1 second. Let me see what's. Just had it. Mr. Mora, give me just a few minutes and let me try to figure out what's happening. I apologize.
No problem, ma'am. Take your time. Ma'am, you have muted yourself.
So, Mr. Mora, it's not allowing me to keep trying to
Ma'am,
do.
I can share it from my side. If you could send it on my email ID. It
Okay,
is
what is your email?
it's Abhijit, Abhijit.
ABIJIT.
Let me write out in a chat box, ma'am.
Okay, thank you.
Is it visible, ma'am?
I will, I've got it, yes.
No, sir.
So, do you have it yet?
No, ma'am, I did not receive it. Oh, I don't know what is the problem. No, ma'am. If you could try once again, if possible.
Okay, gosh. Well, we'll just do it without the, I hate for everybody to wait, so I'll just do it without the, for some reason it's just not working, so.
No problem, ma'am.
All right, so just as a recap for what we talked about last week is, back to that, we're talking about mediation this week, and what we really wanted to remember is that definition that we talked about from mediation, and that you as the mediator control the process. The parties control the outcome. And so again, you heard me repeat that a lot last session. And it is important that you keep that in mind as you are either counsel or you are the mediator, that you are the one controlling just the system and you allow the parties to control the outcome. This is a voluntary process. We talked about setting the table. Just as when you have people come over to dinner, you want to make sure that everybody is at the table who needs to be at the table. And in a future session, we'll talk about maybe how you place the people at the table where they should be. We talked about opening statements and we talked about ground rules. So again, this concept of you are controlling the process, and that discussing ground rules after the problems arise is much more difficult. So having the parties help you establish what the ground rules will be for the mediation is really important. Some of the examples that you can talk about when you're setting these ground rules is in your opening statement, in your introduction to the parties. And maybe that may be in a pre-mediation discussion with counsel separately or with each side separately, or maybe at the mediation itself when all the parties are at the table. Some examples may be to not react to what the other person is saying, not to get emotionally responsive. Remember that you are here to attack the problem. You're not here to attack the person. And reminding the parties that it's important to show respect for everyone at the table. And so that really can help you control some of it, especially when the arguments get a little more heated than you would like them to do. You can look back at those ground rules and say, remember, we talked about some of the ground rules that you would be using throughout this mediation. And one of those was that you would not react to someone if they said something, and that you also agreed that you were going to show respect. And so having those ground rules in place really helps you avoid some issues later on in the mediation, because typically people are coming into the mediation, they may come in with really great hopes and ideas, and then somebody says something unkind or something that the person does not agree with, and then you're left with an angry party on one side who is getting ready to either leave or is beginning to say something unkind to someone, to the other party. And so remember, these ground rules are going to save you as the mediator and really as a litigant or as counsel a lot of problems in the future. Again, I'm just trying to see one more time if I can send this. Another ground rule is having parties speak one at a time. And I think all lawyers have this problem is we are listening in order to respond. And so if you can help your parties understand that you want them to listen with the idea of understanding, not responding, it is a different type of listening, and it will help you, again, avoid some of these problems that potentially could arise. And once you go through those ground rules, I think it is always important, again, to ask the parties, are there any other rules that you think is important in order for us to reach resolution today? In order for the two of you, the two parties, to reach resolution? I think it's really important, and I have a horrible habit of breaking this rule, so I'm going to point this out. Remember that this is the parties' mediation. This is not your mediation as the mediator. And again, you need to use words like we and yours, you and yours, not this is, we are going to come up with a solution. We are going to reach a settlement. It is important for you to remember that to give the parties this power. Remember, you're just controlling the process as the mediator. The parties are controlling the outcome. So it is theirs, yours, ideas. Mr. Moray, did you get it? You sent it one more time.
Sorry, ma'am. Actually, I'm presenter right now, so I could share the PPT if you could send it to me on my email ID again.
I just sent it.
Okay, let me check. I have not received.
So one of the things that we talked about is, it's really easy to mediate when everybody wants to come to the table, come together and resolve the issues. But you're going to have tough issues to mediate, and you're going to have difficult clients that are going to come and try to resolve this issue. And so working with those two issues and those two topics gets really difficult. And so you need to be prepared as the mediator or as counsel for to be ready to address tough issues and difficult clients. So what are some of those things that you consider could be a difficult issue? And if you could just type those in the chat tool for me so I can see what you might consider to be a difficult issue or maybe a difficult client. Mr. Moray, do we have any?
No, ma'am. Right now we have no one to.
No one wants to type anything in the chat tool. Does anybody want to unmute themselves?
If you want to ask anything, you please. You could put your doubts in the chat box if you want. We have no doubts.
No questions.
No
All
question.
right. And have you been able to get my email?
No, ma'am, I didn't receive your email. If in case I could share that thing with you. At least I could share hi or something. Ma'am, it's ABHI and JIT. After that, there will be dot
Yes.
MORE @ MNLU Mumbai.edu.in.
And that's what I have. I copied it right out of the chat tool.
Okay.
Let me see. I'm just going to send this. See if you can get that. All right. So our difficult clients.
We do have question, ma'am.
Yes.
It is, how do we break and communication impasse?
Oh, okay. So I've got some, that's where we're headed in just a moment, is about impasse, because typically what leads to our impasse is that we have these difficult clients and these difficult, tough issues that, again, everybody wants to come to the mediation, or maybe they're required or mandated to be at the mediation, but you've got some difficult issues. And so some of those questions might be to ask, are there any difficult, what has prevented the resolution of this case at this point? What do you think would how would you define that issue? And so as a mediator, you're asking these questions back to the participants. So maybe there's a concern that the parties don't want to be in the room together. Maybe you need to separate the parties. There's a safety concern, or there's maybe a language or educational barrier. And so having the understanding and talking to, as the mediator, talking to the clients, have them reframe the issue. And so when you talk about this concept of reframing, what that really means is having that client, having that individual, that participant look at the issue in a totally different way. And so if the client says, or the participant says, I am not going to settle this case unless I get $1 million. And that's it. And asking that individual, why do you feel that's the only option? Or even a better question, because why questions do tend to put people on the defensive, asking, is that the only option? Then having that individual think about, yes, that's the only option. Why is that the only option? Could there be other alternatives? Or asking, again, remember, we are not here against each other. We're here to defeat this problem. And that problem is this case hasn't resolved. And so asking the client, what do you think will defeat this problem? What do you think will settle this matter? What do you think will get the needle to move, so to speak, for this problem? Asking the party to provide an honest explanation of why their offer or their idea of how this case should settle is reasonable. You put this back on that person. Again, this is they're controlling the outcome. And having that individual explain and really think about why their offer is reasonable, you force them to think about both sides of that issue. And that really helps you start thinking about an impasse. And so what you've got to worry about is parties becoming entrenched, where they just dig in and say, well, if she's not going to give more money, then I'm not doing anything different. And to where that's like, I'm done, that's it, to where you think maybe they're going to walk out or there's no hope for resolution. that is the time when you as the mediator really have the opportunity, again, to reframe this issue and to put it back on the parties for them to develop new ideas. So what was working didn't work. So let's talk about some new ideas and some new collaborations on making this case settle, this case resolve. We're defeating the problem. It's also, again, in this idea of reframing the issue, maybe when you feel like you're so close to an impasse, what does tomorrow look like for you if this case does not settle today? Yeah, oftentimes I say, as the mediator, I get to go home and my tomorrow is not going to look any different whether you resolve this case or not. But tomorrow may look different for you if you don't settle this case today. You may have to get ready for trial. You may have to wait for your opportunity to get to court. You may have to pay more money in attorney's fees. And so having the parties think about what's going to happen if this case doesn't settle today, having them look in the future, I have found that really does help the parties think about, do I really want to be in litigation? Do I really want to be embroiled in this lawsuit, in this conflict another day? I think it is very important for mediators and for both counsels to be familiar with what the next step is, so that when the mediator asks that question, what does tomorrow look like, that the answer and the response is very truthful and realistic. So I always ask, so if you have to go to court, if this case cannot be resolved today at mediation and you have to go to trial, what do you need to do to get ready for trial? And a lot of times that will be taking more depositions, calling in experts. And so when I start asking, well, how much do you think that deposition is going to be? Well, that could be $5,000. Well, how much do you think a week in trial is going to cost? Well, my legal fees are going to be $5,000. And so suddenly taking, $20,000 today seems to make more sense than the potential for uh, money in the future that you have to spend money to get into court. I find it also helpful when we get to a point where you need to reframe the issue, where you're contemplating, I don't think the parties are going to move. I think we're at an impasse. Ask the parties, what do you think would help resolve this case? We've sat here an hour, 2 hours all day, and we haven't made any movement. A lot of times, having the parties tell you, we hear often that people want their day in court. I really think they just want to be heard. And having the parties tell you what it is that they think can resolve the case, sometimes just you listening to their suggestion is important to them and lets them express themselves and then get out of their own way to resolve the case. Addressing the party's behavior, I talk a lot, and again, you need to have developed rapport, a good relationship and trust. And so a mediator's authority comes from this trust building that you've done from the beginning. The parties need to trust that you are going to keep what they tell you in confidence, and that you are helping, that you are this principled negotiator and truly neutral. And so sometimes saying, looking at the party and saying, it seems, based upon where we are today, that you're just not interested in resolving this matter today. Or maybe you're just not able to do that today. Or I understand that you can't do that. Those types of things, depending on that individual. If somebody tells me I can't do something, that's the first thing I want to do. And so putting that back for the parties, if you can't do that, I do understand, sometimes does help. And then just being clear with the parties, help me understand why this is not resolving. Help me understand your position. And having that, again, is that I want to be heard. I want somebody to hear my position because the other side doesn't hear my position. What I find is really important, so when we talk about that opening session where you as the mediator are setting those ground rules we opened with, having the individuals uh, have a buy-in, right? To have them say, yes, I commit to mediating. I am here. In South Carolina, in a family court mediation, the parties have to agree to, by statute, to participate in 3 hours. We don't have a similar time limit in civil cases, but having that party commit to working this process is really important. And, again, hey, Mr. Litigant, remember the opening session when we laid out the ground rules and I told you what was going to happen? Do you remember that? Yes. And do you remember telling me that you were committed to working the process? Still in the process. And so having that conversation just as a reminder, because the impasse typically doesn't happen right after opening session. It happens after you've been at this 2, 3, 4 hours where people are, I'm just done talking about this issue. So again, those are some techniques and tips that'll help you reframe the issue and get through an impasse. But maybe you are at an impasse. And so what do you do? So under our rules in South Carolina, the mediator has a duty, an obligation to timely determine. And there is no discussion on to timely determining when it's at an impasse. But it is the duty for that mediator to determine timely when the mediation is not viable, or that an impasse exists, or that the mediation should end. And so maybe the mediation isn't viable because the proper parties aren't at the table, or your insurance adjuster came and didn't have full authority, or that the mediation should end because truly the parties are not negotiating in good faith. They're not following the ground rules of respect. You get a sense that perhaps this isn't voluntary. And so you need, as a mediator, to make that determination. The lovely thing in our rules is that a mediation cannot be ended without the permission of the mediator. And so if you have somebody walk out, then you just write that in, you just make some determination. Do you think if we let people cool off, will this individual come back? Do we need to reconvene? But the parties cannot, simply by refusing to participate, end unilaterally the mediation. So that gives some authority to that mediator, but it also gives a great deal of responsibility. Again, you've got to timely determine. And I think where this, and it just is, becomes a case by case analysis. Sometimes the mediations that I think are going to end very quickly are the ones that just needed a little more time, and one party needed to be encouraged and listened to more. So don't be so quick to call an impasse. Um, as somebody who is somewhat competitive, I always feel that an impasse is giving up. Don't ever feel like that. What I always do is, even if we feel that impasse has been reached at that point, after talking to all of the parties, and I've explored and used all these tricks and tips that I've shared with you so far, is I will let the parties know it didn't resolve today, but I'm going to reach out to you in a week or 2 weeks, and let's just see where we are. Sometimes knowing when to determine, when being this timely determination of when to end the mediation is really key, because maybe the parties just needed the opportunity to sleep on it, or maybe they realized, I can't do that in a courtroom. For whatever reason, cooler heads may be prevailing, and you can reconvene, have people back at the table. Sometimes I am able just to call one attorney or the other, and we talk about it. I've had some where I've had an actual in-person mediation, and then we did a follow-up via Zoom. And so again, it's just your creativity and what you think as a mediator or as counsel would help to resolve this case. Did that answer that question, Mr. Moray?
Yes, ma'am. Surely. Ma'am, you can share the PPT. I just received your hi on email.
Okay, I'm gonna try it one more time.
From
All right. And so, don't feel like calling an impasse is a bad thing. I think that knowing when, because one of the things that we talked about in the beginning session was being able to
so we have that question from Mr. Lal actually. He has one more
yes.
question. If one party is not communicating, another want to continue the mediation.
Say one more time.
If one party is continuing and the other want to continue and one is not communicating.
So that might be when you realize that the mediation is not viable, that perhaps you need to talk about breaking. Sometimes I think it's important to break before you get too far, before before you damage the relationship. And so, there needs to be a conversation with, why is it, do you think, right, that the maybe that you're not talking? Do you feel like you're not going to get heard? Do you feel like, what is it that is preventing that welcome discussion? And so the knowing, again, having a really good discussion on it's just not letting me send it to you for some reason. I'm sorry. I'm not sure what's happening. So having those conversations beforehand with the individual is important. I'm expecting your participation, and getting that buy-in early on is important as well. And so, those comments that I had shared with you, hey, let's talk about, I noticed that you're not communicating. And we had talked about what mediation is, and you told me at the beginning that you were able to do that. What is preventing you from sharing and working to defeat this problem, right? And taking it from defeating the opposing person to defeating the um, the problem is where I think you can really get a lot of traction from the from somebody who does not wish to participate. Did that answer?
Uh, he want to unmute himself and ask you a question with your
Sure,
point.
yes.
Yes,
Yes.
Mr.
Thanks, Christy. You answered very well my queries. I have a typical question as far as Indian context goes. Whenever a family matter arises in India, first of all, we have come a long way from not discussing the things with the professionals to discussing the things with the professionals. But still, one party gets into a shell and stops communicating before any kind of a mediation which is required before they get into a legal course of action. So, in that case, when the mediation has not yet started, and most of the people prefer to go directly to the litigation rather than getting into an counseling or mediation. So, how do we get that into mediation? That would be really helpful if we can.
Yeah, so in South Carolina, so family court cases and civil court cases are required, with very few exceptions, to be mediated first. So if the party does not mediate in good faith in a family court case, they have to stay for 3 hours, and they have to be productive 3 hours. Then the opposing party can file a rule to show cause as to why that party should not face sanctions. So having the backing of the court system is important. So having a court annexed mediation process, or having the statute that we have, is also could be potentially a way to avoid those issues. Do you think that's helpful, or do I need to you want to talk about this issue? Because this is really, I think, a crux of the issue, is how to get both parties at the table and communicating effectively to resolve the issue, especially when one does not want to go to court and one does.
Correct. I have faced few of such issues where one party who's having a upper position and does not uses non-communication as an impasse unless and until the court forces them for an a court annexed mediation. Otherwise, there is no other way to bring them to the mediation table, even though both the parties are sensible enough to go in for a mutual divorce.
So how do you think, like, what are some suggestions? What are some tips that you have tried or you have seen done?
One of the tips which normally everybody uses here is in India they have a mostly most people have got family and friends who intervene. So
Okay.
they will communicate to either the family or the friends, and they will sit across with the family, and the family sometimes decides and resolves the issue. But if it is not, then normally they, rather than going to the counselors, they approach the advocates. But what happens is that it gives the ego, it inflates the ego of the party that one person has sent us an notice. And that stops it from the mediation and the issue which could be resolved from the mediation. So what one thing which I have tried is to not send the notice in the first place, but rather communicate with the other party, and sometimes it is successful, sometimes it is not.
What do you, when it's been successful, what do you attribute the success to?
Okay, when both the parties have the advocates together, once I had tried on talking to the other advocate, and before we took the case to the court, it got resolved with both the parties sitting together. Initially, one of the party, the other party, was not ready to talk also, not ready to open up. But in that case, what happened? The other party's advocate also was keen on resolution. So they convinced it, and then the party came down. It took almost 1.5 years to resolve the issue without any kind of an litigation. It was resolved in mutual consent. Uh,
How
one case
how
on
long
the
do you think that would have taken if the parties had gone to had not resolved it? How long would litigation have taken?
what would have happened, Christy, would have that litigation would have got into multiple cases, multiple different litigations, and it would have taken more than 3 to 4 years for them to come down and resolve it. But fortunately, both were sensible enough, and they resolved all the issues within 1.5 years.
And so you considered that a success.
To a certain extent, yes, because there were multiple things involved in that, and they didn't agree to go for litigation against each other, and they resolved the custody issue, the issue of maintenance, and as well as they had a joint property together, which they resolved in over that period of 1.5 years.
Oh. What do you attribute? Can you give me an example of what you think doesn't make it successful?
Uh, that also I can tell you, there was one case which had come up to me for filing a domestic violence. In India, you have a domestic violence. There's an act for the lady who can go in for filing a domestic violence. And I had suggested them not to go in for the domestic violence. In the previous case also, I had suggested not to file for an 498A. Again, it was a lady. So the one case which I just mentioned took 1.5 years. In the second case, the lady had come with some kind of an issue saying that there's a domestic violence. I told them, let us not uh, get into that part. Let us speak to the other party. I took the number and spoke to the other party. We had a meeting. The meeting was attended by the husband's father, not the husband as such. That is the direct party, because the husband had avoided to attend that. And second, uh, again we had a second tried to have a second meeting. It got resolved on a particular amount, but in the end, both the for one of the party, that the husband's party, went back on their words for not giving that kind of an amount. And today, uh, both the parties are now, not through me but through somebody else, they are fighting a domestic violence case and an divorce case in the family court. It's almost 2.5 years they are doing that now.
And I wonder how much money that they have spent and time that they have spent not resolving the case when they had the opportunity to do that. Do you have any idea?
Yeah, I think what they have spent is they have already lost 2.5 years. And with the kind of COVID situation, I think it would easily take another 2 to 3 years for them to resolve it. And
Okay.
obviously, they both of them have got their own advocates, and they are also going ahead with one more case. So there would be, if there is another case, they would be fighting three different cases, which could have been resolved and resolved easily, and they could have gone ahead with their lives peacefully, and even the children would have been better off in that case.
So I think that, um, it took a long time for mediation to be a viable alternative in South Carolina, to where it is mandatory for all family court cases. And so I think that a couple of things need to happen. So your family court bar should talk about how beneficial mediation is, not just uh, for the parties involved, but for the children. And so when we talk about the purpose of mediation, and I've heard it both times prior to my introduction, is that this concept of family court is to preserve marriage. And so maybe we're not in dissolving a marriage, maybe we're not necessarily preserving that marriage, but we still in mediation have the ability to preserve relationships, especially when the uh, the marriage involves children, because we all know children don't go away. Um, and so preserving relationships really should be the key. And so having a vibrant and accepting family court bar that says mediation is important. Mediation is important not only legally, but also at our very cultural core when we talk about this preservation of the sacred institutions and relationships. I think that there's some attorneys, they go to law school and all they want to do is litigate and argue. I'm sure you all hear, I went to law school because my mom or dad told me I argue all the time. And so those attorneys think that's what I need to do. And it's really hard. I started last week with that picture of mediation is not litigation. Mediation, it does not take place in court. And so it's really hard, especially for some attorneys who love that thrill of being in the courtroom and being this zealous advocate. It's hard to put a different hat on at the mediation table. And so having the ability to talk amongst your peers, amongst the family court bar council, is really important about how mediation can really help. And I've heard and I've read some of the cases where we talk about community mediation. And I volunteer at our community mediation center, and it is really so important, especially when we have cases between a tenant and a landlord where there's some issues with rent or something like that. It's the same concept, and having somebody who is from that community listen to both sides and to know the family background, and to really then say, again, that question, if we don't do this today, what is your tomorrow going to look like? And what is your tomorrow for the next 2.5 years going to look like? And now, because of COVID, what's your tomorrow for the next 5 years potentially going to look like? And really emphasizing all the things that mediation is, and and really dispelling those negative stereotypes of what mediation might not be. I hope that answered that question. I think it's a multi-leveled approach. What I understand is there was a mediation bill that did not pass this past fall that and y'all would know certainly much more than I do about that, but um, really encouraging to start this very vibrant mediation practice. There's really, I loved as a prosecutor, I tried cases. As a defense attorney, I tried cases. As a judge, I presided over hundreds of cases. I love the courtroom, but I also know that there's no winners in a courtroom, that somebody is leaving, and most times that both parties are leaving. And at a mediation, there's so many other remedies that you can do besides just awarding cash, which is what a verdict is from a jury. And I know y'all don't have a jury system, so you have a judge doing the same thing. And, you know, the mediator, and a good mediator, helps the party guide through those issues, guide through this problem of, well, he's not going to talk at the mediation and he stopped participating. Having a good understanding of what a mediation is, and you know, and really, you've got to have sometimes, for those recalcitrant people that don't, you do need to have some sort of hook with the court, or some sort of sanctions at the end if they don't participate. I
Yeah,
hope
thanks.
that's,
Thanks
yeah.
a lot. I would like to share one more thing. You asked me about the success
Yes.
part.
Yes.
Then second, a couple with the second marriage, the lady had the husband had passed away. She had a daughter, and the another part, that is the husband had was also divorced. They had come for a divorce, but after the mediation, now they are living together and they are living happily.
So the mediation, so you feel like that was a good thing, or?
Obviously, it was a good success, and it's good to see them keeping the relationship alive and living together.
And so what do you attribute that success story to?
As you rightly mentioned, how to make them open up to each other, talk to each other, and solve the issues which were basically very minor issues. When they spoke about it, they resolved it themselves.
Well, I love to hear success stories. And so are you a fan of mediation? Are you a
Yeah.
big proponent and advocate?
Yes.
Good, good. Because you've probably seen the benefits far outweigh any negatives. And usually what I tell parties when they come to the table is, you're not losing anything by being here. And so give the process a chance. You may be, it may be 3 hours out of your life, and you may have to pay the mediator's bill, but in the grand scheme of things, when we're talking about a court date not before 2.5 years, what are you giving up other than the opportunity for a successful resolution? And again, reframing the issue is of, well, I'm not budging until she budges. Well, I'm not going to give in until she does. Having a mediator, and it does take work. And the most successful mediations that I've had is, when I break the parties up into a caucus after, preparing beforehand, having the introduction and hearing the opening statements, then I will break the parties into a caucus, to where I will put one side in one room and one side in the other. And we talk about what that looks like. And so they know. And the most successful mediations, in my opinion, are the ones where the counsel is also, during those times when I'm going back room to room, is also having conversations with their client about, think about this, and encouraging and being really a cheerleader for the process as well. That, again, if we don't resolve this today voluntarily, in a manner that you're comfortable with, the next step is trial. The next step is a lengthy discovery process. The next step is whatever that next step may be. And so again, you've got a lot of parties, you know, the attorneys are working together with their client, knowing that resolution is in their client's best interest. And you know, when we start talking about this luxurious litigation and the high cost of litigation, I think that counsel needs to take a good look at why did you take this case and what really what's your ultimate oath for your client, and professionally responsible uh, conversations so that your client is actually getting out of that situation in a resolution that preserves that relationship that's valued, and taking that time for yourself. You know, I know there's many interests, and most of us went to law school because we wanted a better life for ourselves and our family, and we wanted to make a good living. But you can do all of that and still preserve and have integrity and preserve the relationships. So we are right at the top of the hour. I know it took us a little long to get started today, and I apologize. And I do not know I can see my PowerPoint right there, and I don't know what happened. So I'll take a couple of more questions, or I'd love to hear I'll be back on Friday. I'd love to hear what you want to talk about on Friday, if you have any suggestions.
Christy, can you hear me?
I can hear you. Yes.
Okay, great. So I have a suggestion, which
Yes.
my observations in family court was that going for mediation after the petition is filed is just more like a formality, because we come with as when I say we, I'm talking about our clients, come with the notions that this is not going to work out, right? So when I go for mediation, there is no effort to really work towards improving upon anything. So the suggestion is that, wouldn't it have been better that, knowing that they want to go in for a divorce, they start with the mediation to begin with, and then depending on what the outcome is of the mediation, you take it further in terms of whether it has to be a contested divorce or whether it has to be mutual divorce. Because getting mediation in the beginning itself will probably open up their minds too. I'm saying because the mediator is qualified to look into these kind of issues, they probably could help in taking uh, in changing the course of the whole you know process. So isn't it better than me already filing a petition, because I've already started the war when I filed the petition, and I'm saying, isn't that a better approach than coming this approach which we are doing in India?
So what do you think?
I
I'll
think
give you, I'll
I
share
think
you my views, but
no, I personally believe a mediator should come at a stage, and especially in family matters, to help me understand how much time, energy, money am I going to waste before I could even file the petition. And that will help me, like you said, to preserve my integrity, feel good about the whole thing as an advocate too. So I am
yes.
saying that should be the approach, that let me first take it to the mediator, all right, which is a mandatory thing which is done by the court. And only after that, because we want to preserve the marriage as an institution, we take it to the next step. So if it's impossible, then you do a divorce, which is contested, or most of the divorces, if the mediator really plays a good role, could result in mutual consent, and it can be more amicable and settle faster.
So it takes again, and I like one of the comments, advocates of the parties need to take proactive role for mediation and convince the parties to give mediation a try. And
Yes.
so again, you've got to have both not just both parties to the matter. You also have to have both advocates willing to give this a try. I agree with you. I think that the earlier that you can get this resolved into a mediator who is skilled in mediation, not who is there just to check a box for the parties, but somebody who is skilled and really and everyone at the table is working for the same goal. I do find that sometimes it is the pressure of an immediate court hearing or a trial that really forces somebody to take a different look. Maybe I need to go to mediation and participate uh, as we've talked about this today, because the judge may not see it that way. I may get a worse result if I litigate, or I will be spending more money, whatever adverse reaction. You know, attorneys in my world, and we talk about our procrastinate, to wait till the last minute. And so a lot of times I'll get, as a mediator, I'll get a call, can you mediate this case? We're on the trial docket in 2 weeks, and we need to get this thing settled. So I hear you. I wish that everybody would would mediate, especially in family court matters, before filing a petition. But there is human nature sometimes that having this deadline up against does push people to settle. But I think that having especially in law schools and in your bar meetings, having a conversation on this very topic, having CLEs and educational awareness about this really benefits everyone. And I think, you know, when you talked about preserving your ethics, uh, billing and just billing and for hours and hours in the courthouse, uh, you know, is something that may give you some pause as an advocate, when you know that this could have and should have resolved itself at mediation. I hope that answered your question. I thought that was a great question, but again, I think it's back to this education and awareness and having counsel be comfortable with appearing in mediation. I think some counsel feel like they're giving up some discovery issues, that they're revealing client confidences during mediation, and so that it's going to negatively impact them at trial. And really having a conversation and setting up the boundaries for mediation, a clear, confidentiality discussion could alleviate all of those concerns and fears.
Thank you, Christy. That helped. Thank you.
Thanks. Time for one more, or if, you know, if anybody just wants to put in the chat tool, we've got 4 more sessions, I think, together. So let me know what other topics, or if you're just have a particular question. And I'm going to put my email. If there's something, you know, if you want to write and just let me know that you've had a particular situation, experience, and maybe some ideas or tips to handle that particular situation, or if I've seen that and how I handled it. I'd love to. Again, I'm so glad that y'all were asking questions. It really, I want this to be beneficial to you. Again, I love ADR, and I just really have seen where people did not utilize it and really lost money and friendships and relationships, and things that they could have avoided, stress, 2.5 years of litigation that they could have avoided if they had just come to the mediation table and been willing to listen to the other side and to evaluate their position for reasonableness and really think about the larger picture as to what's happening and to work through that impasse attitude that we talked about earlier. So I'm gonna I'll hang around for just a few moments. And again, I apologize for the technical issues. I'll make sure that that does not happen on Friday. I had some really cute, funny mediation jokes to share with you today, but we'll save them for Friday. But please reach out and let me know what I can do again for Friday to make this more personal for you. Thank you again for spending your Tuesday evening with me. It's now 9 a.m. in South Carolina, so I am off to go teach baby lawyers at our law school here, and look forward to seeing everybody on Friday and morning for me, afternoon for you. So thank you. I'll be here for
Thank you
just
so
a few
much.
moments.
I hope you have enjoyed today's session, today's interactive session. Hello.
Hello. Yes.
I hope you enjoyed today's session, ma'am.
Oh my gosh, I'm so excited. Lots of great questions. Lots of great questions.
We have next session on 4th of February, so that will be more interesting for you.
Yes.
Mhm.
Yes. So any topics you can think of, Mr. Moray?
Sorry, ma'am.
Any topics you would like for me to cover?
Uh, I will let you know, ma'am. I have your email ID. Once I get the
Okay.
clarity, I will convey you the same.
All right. And I'm going to try, I probably just need to shut down and restart. I don't know. It kept saying that my PowerPoint was open somewhere else and I couldn't find it. So I apologize for that. So I'll make sure that I get that to you. Let me make sure I have your personal email as well.
Yes, ma'am. I have sent you my personal email as well. If in case
I just copied it out of the chat.
for the next session, that could be useful.
Yes, just and I'll try to go ahead and send you that PowerPoint so we have it all pulled up and just in case. So I don't know what happened. That's never happened before.
So, should we end the program, ma'am?
I think so. I don't think anyone has any more questions. And again, thank you all for
Thank you very
spending
much.
your
It is my
afternoon.
indeed pleasure to extend vote of thanks for today's session. So
Thank
first, I would
you.
like to thank our resource person, Miss Christy Harrington, ma'am, for her explanation on the recent development on mediation. Also, I would like to thank Shashidhar Nair, the president of Family Court Bar Association, for collaborating with our institution. And special thanks to our Honorable Vice Chancellor, Professor Dr. Dilip Uke sir, for motivating us to conduct such a webinar. Thanks to all the participants for actively engaging and being so cooperative. Thank you very much. And with the permission of ma'am, I would declare the closure of program. Thank you very much.
Bye-bye.
Bye.